Hello and welcome to Forbes Let's Talk Employment Law edition. Today we'll be talking about the general election. We've already seen many employment law changes in 2024, and whilst we knew that a general election had to be called before January 2025, we didn't necessarily expect a general election to be called as soon as July. The Conservatives, Labour and Liberal Democrats have all now published their manifestos, setting out their proposals of the changes they would like to make if elected. Within these manifestos, there are some interesting changes to employment law planned, meaning that whichever party wins the election, there will be changes to employment rights which businesses need to be aware of. So Emma, what's contained in each of the manifestos? I appreciate that these are lengthy documents, but it'd be useful to understand the employment law highlights in each of these. Shall we start with the Conservatives?
Thanks, Kat. The Conservative Party published its manifesto on the 11th of June 2024. What strikes you when you're reading this is that it is quite light on specific employment law pledges. It does quite clearly state, though, that if re-elected, the Conservative Party would never introduce Labour's package of French-style union rules, and also would retain the flexible and dynamic labour market that gives businesses the confidence to create jobs and invest in their workforce. So clearly the Conservatives are not going to adopt the interventionist approach which Labour seems to be championing. When you delve deeper into the detail of the manifesto, there are some employment law proposals in there which will be of interest to business owners. The Conservatives plan to continue implementing the Strikes Minimum Service Levels Act 2023, which attempts to alleviate the disruption caused by strikes by specifying minimum service levels for certain public services. Now, this has promoted quite a strong reaction from some unions, with the Fire Brigade's Union General Secretary suggesting that this proposal is a further declaration of war on trade unions and workers' rights. The fit-note process would be overhauled so that people are not signed off sick as a default. A new system would be introduced where the responsibility for issuing fit notes will be moved away from GPs to specialist work and health professionals. The Conservatives also plan to test integrating this with the new Workwell service to provide tailored support to help people stay in or return to work. The national living wage, which is a minimum hourly rate that can be paid to those who are aged 21 and over, would be maintained at 2/3 of median earnings in each year of the next Parliament. On current forecasts, that would mean it rising to around £13 per hour, which could be quite a significant financial burden for many businesses. The Equality Act 2010 would be amended to clarify that the protected characteristic of sex means biological sex. Legislation would also provide that an individual can only have one sex in the eyes of the law across the whole of the UK.
Thanks, Emma. And apprenticeships feature quite heavily in all the manifestos. What does the Conservative manifesto say on this point?
The Conservatives state that they would create 100,000 high-quality apprenticeships in England every year by the end of the next Parliament, which would be funded by curbing the number of poor-quality university degrees, which is quite a bold statement from them. There are some tax provisions included in the manifesto too, such as an additional 2p would be taken off employee national insurance contributions so that it will be 6% by April 2027. And the main rate of self-employed national insurance contributions would be abolished entirely by the end of the next Parliament. The Conservatives would also introduce mandatory national service for all school leavers at age 18. Young people could choose between a competitive placement in the military or civic service, which has grabbed a lot of the headlines and also caused a lot of concern with my two teenage boys at home.
I can imagine. There are some interesting proposals here. I understand that there is already an ongoing challenge of the government's decision to impose minimum service levels during strikes.
Yes, that's right, Kat. The High Court has recently granted the Public and Commercial Services Union permission to pursue a judicial review of the government's decision to impose the minimum service levels during strikes. There will be a substantive hearing on that later this year.
And some of our listeners may also be aware of ongoing consultations already in place on some of the pledges contained in the manifesto.
Yes, as part of the Back to Work plan, which was announced by the government in 2023, there was a commitment to explore a reform of the Fit Note process. Therefore, the inclusion of the proposal for a reform of the Fit Note process was expected. There is a current call for evidence on Fit Note reform, which ends on the 8th of July of this year.
Okay. And is there anything that isn't included in the manifesto that we expected to see?
Yes, the manifesto is silent on the reintroduction of employment tribunal fees, introducing a statutory cap of 3 months on non-compete clauses in employment and worker contracts, and the development and improvement of the current whistleblowing regime, all of which have been the subject of recent consultations and reviews and were expected to feature.
Thanks. So are there any employment law proposals included in the Liberal Democrats manifesto that businesses should be aware of?
Yes, there are a number of proposals contained within this manifesto that will be of interest to businesses. There is a plan to replace the apprenticeship levy with a skills and training levy and scrap the lower apprenticeship rate of the national minimum wage. This is currently at £6.40 an hour for those who are aged under 19 or age 19 or over and in the first year of their apprenticeship. If this rate was increased, it could have significant financial implications for many businesses that utilise apprenticeships. Continuing on the theme of the NMW, the Liberal Democrats plan to create a new carers minimum wage, where the minimum wage for carers would be increased by £2 an hour. Alongside this, a worker protection enforcement authority would enforce the national minimum wage, tackle modern slavery and protect agency workers. There is also a plan for the lower earnings limit for statutory sick pay to be removed, and the rate of SSP would be aligned with the national minimum wage. There is also a plan to make payment available from the first day of absence and consult small employers on providing support with those costs. There would also be an introduction of a dependent contractor employment status with entitlement to basic rights, including minimum earnings, sick pay and holiday entitlement. And if employment status is challenged, employers would bear the burden of proof in employment status tribunal claims. The dependent contractor does seem like this is a similar, if not the same, as the current status of worker, so we would need to see some clarification around this.
I think we would. And are there any changes to employment rights contained in the Liberal Democrat manifesto?
Yes, there are. Those of note include that, subject to significant business reasons, everyone would have the right to flexible working and every disabled person the right to work from home. Staff in listed companies with more than 250 employees would have a right to request shares to be held in trust for the benefit of employees.
So all parties seem to be suggesting changes to the Equality Act. Is that the same for the Liberal Democrats?
There is quite a unique proposal, actually, to make caring a protected characteristic under the Equality Act 2010, along with requiring reasonable adjustments for employees with caring responsibilities. There would also be an introduction of paid carers leave, along with guaranteed regular respite breaks. There would also be the introduction of a weekly allowance for all kinship carers. There are also some proposals to enhance family-friendly rights, such as the introduction of paid neonatal care leave, making parental leave and pay day one rights, including for adoptive parents, kinship carers and self-employed parents, increasing statutory maternity and shared parental pay to £350 a week, increasing paternity pay to 90% of earnings with a cap for higher earners, and introducing a use it or lose it month of leave for fathers and partners, paid at 90% of earnings with a cap for high earners. This may actually represent a saving for employers, as many already top up maternity benefits for their employees. This would also bring the UK closer to the norm in other high-income countries.
And are there any equality, diversity and inclusion proposals that may be of interest to businesses?
The Liberal Democrats want to encourage use of name-blind recruitment processes. So that means removing a candidate's name and other personal information, such as their nationality or the university they attended, for example. This can, of course, help to build a more diverse and inclusive workforce that better reflects society. There would also be a requirement for large employers to publish data on gender, ethnicity, disability, and LGBTQ plus employment levels, pay gaps and progression, and for there to be an introduction of adjustment passports to move support and equipment between jobs.
Thanks, Emma. So finally, looking at the Labour Party, they'd already set out their proposed changes to employment law prior to the publishing of their manifesto. Is that correct?
Yes, it is, Kat. Labour had previously produced an employment rights green paper called A New Deal for Working Paper, and then followed this up recently with Labour's plan to make work pay, delivering a new deal for working people. These documents contain some quite significant changes to employment law and workers' rights that businesses really do need to be aware of. Those that are of particular note are as follows. Exploitative 0-hours contracts will be banned, although there isn't a definition of what would constitute exploitative. There is a proposal to give rights to employees to have a contract which reflects the hours they regularly work based on a 12-week reference period. Previously, there was a commitment in the Green Paper to give full pay to 0-hours workers for any shifts which were cancelled without appropriate notice. But this has now changed to compensation that is proportionate to the notice given. The Make Work Pay document also makes it clear that employers will also not be prevented from offering fixed-term contracts, including seasonal work. There is a plan to move towards a single status of worker and transition towards what Labour describes as a simpler two-part framework for employment status. There is a commitment from them to consult in detail on a simpler framework that differentiates between a worker and the genuinely self-employed. The Make Work Pay document correctly references the confusion that exists around employment status, but this is something that has been in the pipeline since the Taylor Review in 2017, so I think that it is unlikely that this will be straightforward.
Yeah, there certainly won't be a quick fix on this, I imagine. So I understand that Labour are looking at fire and rehire and considering an outright ban on this practice if they're elected.
It's worth mentioning that this is something that is already the subject of a draft code of practice that the current government are bringing into force on the 18th of July 2024. Within this code, it suggests what businesses should do if they are contemplating dismissing and re-engaging on new terms and conditions. Labour did seem to be looking at implementing an outright ban if they were elected. However, the Make Work Pay document, there is an acknowledgement that it is important that businesses can restructure to remain viable and preserve their workforce and the company when there is genuinely no alternative. This statement seems to water down the outright ban on fire and rehire that had previously been planned by them. There is also a new reference to ending fire and replace, where a workforce is dismissed and replaced by a whole new workforce on lesser terms and conditions. Another interesting proposal is that Labour have confirmed that if elected, they would give day one rights for all workers, ending the current arbitrary system that leaves workers waiting up to 2 years to access basic rights of protection against unfair dismissal, parental leave and sick pay. The reference here to worker is confusing. Are Labour planning on giving workers in their current form a whole suite of new employment rights? I suspect that they have referred to worker as they plan to introduce this new status of worker for all but the genuinely self-employed at the same time as these day one rights. But this proposal is now only going to be consulted on and won't be implemented straight away. So we'll just have to wait and see. Whilst unfair dismissal will be a day one right, a fair dismissal would include dismissal in a probation period. This means that businesses would need to ensure that they have their policies and procedures in place to ensure that probationary periods are in place and proper procedures are followed if an individual isn't a right fit for the business and won't be passing their probation. Alongside this, there is a proposal that the time limit for bringing a claim at the Employment Tribunal would increase to 6 months for all claims. The pledge to remove the statutory caps on compensation and for directors to be personally liable for a failure to comply with the Employment Tribunal orders are no longer contained in the Make Work Pay document, and this isn't referenced in the recently published manifesto either.
These are quite significant changes if Labour are elected. So are there any changes to family-friendly rights planned by the Labour government?
Yes, there had been a plan to overhaul shared parental leave and pay, extend maternity pay, etc., but this isn't included in the Make Work Pay document. Instead, there is a commitment to review the parental leave system within the first year of a Labour government. I assume they mean family-friendly rights rather than statutory parental leave, but this isn't clear. There is a proposal to introduce a right to bereavement leave for the loss of a loved one, and the benefits of paid carers leave would be examined. There is also a proposal for the right to work flexibly to be the default for all workers, except where this is not reasonably feasible. So does this mean the 8 statutory reasons for turning down a request will no longer be available? I think that this may be the case. Of course, the right to request to work flexibly is already a day one right from the 6th of April 2024. There will also be a right to switch off brought in, where workers will have the right to disconnect from work outside of working hours and not be contacted by their employer during these times. This reflects the concept which is already in place in countries such as France and Belgium. It looks like there will be a change to redundancy consultation provisions, meaning that the case of Usdaw and another versus WW Realisation 1 Limited in liquidation and Ethel Austin Limited and another, which is often referred to as the Woolworths case, will effectively be reversed, and the duty to collectively consult will occur when looking at the number of redundancies over the whole business rather than at each workplace, which is the law at present. In addition, it references Labour will also strengthen the existing set of rights and protections for workers subject to TUPE processes. But do they mean here workers as they are at present? We must remember that there is a government consultation on if a worker should be included in the wider definition of employee for the purposes of TUPE already.
Thanks, Emma. So if elected, we would expect a Labour government to strengthen trade union and collective bargaining. So is this something that's included in the manifesto and the Make Work Pay document?
Yes, unsurprisingly, Kat, there are plans to strengthen the trade union powers and to make it easier for trade unions to enter workplaces to organise, meet and represent their members, along with simplifying the union recognition process itself. It is worth noting that there is a proposal to place a proactive duty on employers to inform all new employees of their right to join a union and to inform staff of this on a regular basis, and for this to be included in the Section 1 statement issued to all staff. I think it would also be fair to say that the Strikes Minimum Service Levels Act 2023 probably wouldn't survive under a Labour government. There will only be fair pay agreements in adult social care and not for the wider economy, as was originally pledged, and there's a proposal to make it easier for workers to raise collective grievances via ACAS.
Thank you. So for many in the hospitality industry, they'll be aware that there is currently a draft statutory code of practice on the fair and transparent distribution of tips, which was approved by the House of Lords in May of this year, but regulations are awaited to bring this and the remaining provisions of the Employment Allocation of Tips Act 2023 into force. So what do Labour propose to do on this?
The Make Work Pay document states that Labour will strengthen the law to ensure hospitality workers receive their tips in full and workers decide how tips are allocated, which is slightly different wording to the current legislation. We shall need to see what a Labour government does about this if they are elected. It's also worth noting that the Labour government planned to remove the current age bands in place, which determines the level of national minimum wage payable, so all adults receive the same rate, which will be significant for businesses that would normally pay on or around the national minimum wage, especially in that hospitality sector.
Of course, of course. So was there anything missing from the Make Work Pay publication that we had expected to see?
Yes, there is. There had been murmurings about Labour planning to abolish the apprenticeship levy and replace this with a growth and skills levy, and also to introduce a new Race Equality Act to tackle structural racism, but these weren't included in the Make Work Pay document. However, now the Labour manifesto has been published, it is stated within this that Labour will replace the apprenticeship levy with a flexible growth and skills levy, with Skills England consulting on eligible courses to ensure qualifications offer value for money. In addition, Labour have included in their manifesto a pledge to introduce a landmark Race Equality Act. There is also reference in the manifesto to Labour introducing protection from menopause discrimination, which we hadn't seen before, although there had been a proposal that employers with more than 250 employees would need to produce a menopause action plan, along with a commitment to strengthen protection against dual discrimination.
So if Labour do win the general election, does that mean employment rights will change immediately?
In Labour's plan to Make Work Pay document, it suggests that there will be a full and comprehensive consultation on the implementation of the New Deal. It confirms that legislation will be put before Parliament within 100 days of the Labour Party entering government, with an implementation period as is standard following royal assent. This doesn't mean that it would become law straight away, and it is likely that it will be draft legislation, considering the pledges to consult on any changes, such as the move towards the single status of worker and a review of parental leave. It is noted that many of the proposed reforms have been debated for years, as far back as the Taylor Review in 2017. So some of these proposals could be included in the employment bill and acted on quickly. One example of this would be creating the single enforcement body. Where substantial secondary legislation is required, Labour say that they will engage with experts and stakeholders, including employers and trade unions. There is a parliamentary summer recess, which is normally late July to early September, so that may factor into the timescales for any planned changes too. It is worth noting that there are some other proposals contained in the plan to Make Work Pay that don't require legislation. For example, they commit to writing to the Low Pay Commission to change its remit, requiring it to take account of the cost of living. Of course, if the Conservative government win the general election, then it is expected that the current legislative agenda regarding employment law would continue, such as the right to neonatal care leave and pay that is currently due to come into force in April 2025.
So the intention by Labour to change the qualifying period to claim unfair dismissal to make it a day one right is something that many businesses are interested in. Is this a standalone change that could be made pretty quickly if Labour were to win the general election?
Yes, I suspect that most businesses, this is high on their to watch list. There have historically been many changes to the qualifying period needed to bring an unfair dismissal claim, changing from 6 months service to 2 years. The most recent change was in 2012, where the qualifying period of continuous employment for unfair dismissal rights was increased from 1 year to 2 years. Looking at the process that was followed then, the change to the qualifying period was made by Article 3 of the Unfair Dismissal and Statement of Reasons for Dismissal, Variation of Qualifying Period Order 2012. The order was made on the 30th of March 2012 and came into force on the 6th of April 2012, so that was pretty quick. It is worth remembering that there were transitional provisions which provided that the change in qualifying period did not have effect in any case where the period of continuous employment began before the 6th of April 2012. Process-wise, an order cannot be made under the provisions contained in the Employment Rights Act unless a draft of the order has laid before Parliament and approved by a resolution of each House of Parliament. As you'll see from 2012, the abolition of the qualifying period could potentially be done quickly from a legislative process perspective. However, there is references throughout all of the proposals made in the various publications that Labour have produced to consultation. So we would expect that there will be consultation on this point and the intended changes to the rules on probation periods. We would also expect there to be transitional provisions as there have been previously.
Thanks very much, Emma. We've clearly got an interesting time ahead. We hope you've enjoyed listening to this podcast.